Second. Back. Mike. Twenty. Second. Started something. And submit. Third. Here. Fourth. So I'll have you get involved. And balance. And to the right. Station. Some are one. And four. Then pick up. Cost. Done in terms of cost. That we. That's contact. So. In the virtual, you can see slide. So now. So all. Well. Thank the sure. Remember. Secret committee. This and one. The co-op. Chapter. You're good. You know. Sir. Here. The bike here. The other.
On commercial litigation involving restricted covenants, trade secrets, computer fraud, and other. Company that's headquartered in Helsinki, Finland. The company was established in 1920 and has developed into a global leader in sustainable chemical solutions for water-intensive industries, with a focus on pulp and paper, water treatment, and other related industries. In her present role as America's General Counsel, Susan provides legal advice on matters as to the company's business for transactional, regulatory compliance, employment, litigation.
Mike, I appreciate everybody and for program today. Mission very hot, particularly in the last couple of months. From this thing, Mark's able to come up, see you. I would like to let Mike on. Great. The agenda that we have today in talking about the rule.
Thank you. Can everybody hear me? Okay, great. Yeah, so our agenda for what we're going to cover today is really kind of an in-depth look at the Federal Trade Commission's rule. The starting point is going to be, how did we get here? This has been an evolving process to get to the point where we have this now promulgated rule that bans non-competes. We're going to talk about kind of what the lead-in is to how we got to that point. We're going to talk about what exactly does the FTC's rule do. We're going to also talk about what are the exceptions to the rule, because the rule, while it's a broad-based ban, it doesn't apply to every single existing non-compete, even though it does ban all non-competes on a go-forward basis. We're also going to talk about what's the notice requirement. That's going to be an important takeaway for companies that are navigating this. What's the process? What do you have to do? And kind of how do you go about it? As many folks who've been following this know, there is significant litigation challenging the validity of the FTC's rule in multiple jurisdictions. We're going to kind of talk about where that stands and what that means both for in-house lawyers and outside counsel in evaluating how to advise clients and how to advise your organizations on what to do while these challenges are pending. We're also going to touch on other state law non-compete developments that equally impact how companies can and should protect their trade secrets. And we're going to talk more generally about, with this FTC rule looming, what does it mean for trade secret protection, and what should employers be doing to protect their trade secrets, regardless of whether this rule stays in place or if a court finds that it is not a valid rule. So with that, I'm going to turn it over to Ben to talk about how we got here.
Thanks, Neil. Yeah, I mean, a lot of people are probably scratching their heads wondering, how is it that we got to the point where the federal government is involved in trying to regulate and ban non-competes? And I think if you look at the issue, here we go, I got it, Neil. A lot of it can be traced back to Jimmy John's in 2014. That's when sort of the use and potentially the abuse of non-competes burst into the sort of mainstream media and became an issue that people started talking about outside of legal circles or academic circles. And if you're not aware of what Jimmy John's was doing, Jimmy John's had non-competes with every employee that worked for the company or one of their franchisees that prohibited them for 2 years from working basically for any sandwich shop within a 3-mile radius, not just to the location they worked at, but of any Jimmy John's location anywhere in the country. So, if your son or daughter went to Chicago for college and worked at a Jimmy John's and then came back to Atlanta and wanted to work at a Subway that was within 3 miles of a Jimmy John's, their non-compete prohibited them from doing that. Needless to say that once word got out about that, there were investigations. The Illinois and New York attorneys general got involved and ultimately reached settlements with Jimmy John's that stopped that practice. But that's, to me, sort of when all of this began, and it really it plays out if you look at the timeline from that point forward, in terms of what the federal government started doing relative to this issue. And, since this is an IP group and an IP section, I think it's worth talking about what was Jimmy John's thinking. And, candidly, their rationale was, well, we're teaching people how to make sandwiches in a way that is faster than everybody else. And we don't want them to be able to use that incredible knowledge we're providing them with other sandwich shops. And so, I think what we've seen is that when there's an abuse by industry or by business, that's when the government gets involved, and that's really what's happened here. So if you look at it in 2014, that's when sort of this consciousness about the use of non-competes arose. The Obama administration, there was a Treasury report that talked about the potential economic impact of non-competes. But critically, I think what was really important is that at that point, the Obama administration issued a call to action to the states, that this is a state law issue and that the states should be dealing with any use or abuse of non-competes. And that started to happen. What we really saw, and we'll talk about it later in the presentation about some of the state law developments that companies need to be aware of. But the states started really passing legislation that started to curtail the perceived abuse of non-competes. And so you would think that that's in our system of government, maybe how it would play out. But then really it was in 2018 when the FTC got involved. They were being pushed by members of Congress. And at that point, and you see this throughout, it really has been a bipartisan issue. I think now with the FTC rule, the vote in favor of the rule was along party lines, and it appears that this is becoming more of an issue that either side does not agree on. But it really started out at that stage as something that was bipartisan, and that's also played out. We'll talk about some of the legislation that's been introduced in Congress on a bipartisan basis that would either curtail or ban the use of non-competes as well. So then in 2020, the FTC holds workshops, but then it was really in 2020 that President Biden, as part of his campaign platform, included his intent to ban non-competes. And that was certainly, at least in my experience, the first time I had seen any kind of national a campaign for president or any national office, include any reference to non-competes, much less a ban. And then when President Biden was elected, he issued an executive order basically asking the FTC to look into this issue further, or directing the FTC to do that. There were additional workshops. And then in 2022, that's when the FTC started issuing guidance on the issue and entered into a memorandum of understanding with the NLRB on the issue and a strategic plan for the path forward to regulation of non-competes. Interestingly, it was around maybe not this time last year, it's probably March of last year when President Biden gave his State of the Union address. He actually mentioned the ban on non-competes or potential ban on non-competes in the State of the Union address. And in 30 plus years of practicing in this area, I never thought I'd hear the President of the United States talk about non-competes in a State of the Union address, but that kind of shows where this issue, the consciousness of this issue and where it's gotten to on the political side. So then it was in 2023 that, or January of 2023, that the FTC issued the proposed rule and request for comments. And also at the same time, we'll talk a little bit more about this, engaged in some enforcement actions that I think are as important as this rule for companies that use non-competes to be aware of. And then earlier this year, they issued the final rule that we'll be talking about. So just real quick, what is the FTC's rationale? They say that non-competes reduce worker wages, that they stifle innovation and development of new businesses. They exploit workers and burden economic liberty, and are not the only means of protecting employers' interests and confidentiality, in particular with respect to trade secrets. I think if you look at the studies and the literature on which the FTC bases the rule, for every study that says that non-competes either reduce worker wages or stifle innovation, you can find another study that says the opposite. And whether there is a correlation between non-competes and those things, I think is very much subject to debate. And that's one of the grounds on which the rule is being challenged in court, even if it's not the most significant one.
William and Susan, while we're setting the stage for talking about what the FTC's rule is and what it does, I'd like to give each of you an opportunity to talk about your companies, your organizations. What are the types of trade secrets and confidential information that you have, and how you're protecting them, and then particularly give some perspective on how the organizations use non-competes or view non-competes as a tool to be protecting trade secrets within the organization. And William, I'll let you go first if you'd like.
Good. Thank you, Neil. Thank you, everyone, for having me. Happy to be here and participate in this. We do take this as a very serious issue, a very serious matter. Wencor Group is an aerospace company. We have a host of subsidiaries that are all in the aerospace. We manufacture, distribute, and repair aircraft components. Our major customers are airlines and other maintenance organizations that support the repair and overhaul of aircraft. So if you can think of an airline in the world that's within a jurisdiction that's legal to do business with as a U.S. company, we probably sell to them in one way or the other. So we do consider ourselves to be very IP-centric, which is a little ironic because Wencor and our subsidiaries, we do not have a single patent that we hold. So trade secrets are very important to us. We pay a lot of attention to them and take measures through our policies and our procedures to protect them. And certainly that extends to our employees and our contractors, but also working and contracting with our suppliers and our customers. So it's an important area for us. The non-competes provisions, it's a powerful tool, in order to help protect that. I think there are legitimate business reasons to have non-competes outside of IP protection. And certainly there are some other ways to enforce those. And I think that's one of the things that the FTC is really kind of hung their hat on here, is that you have these other tools that are available to you. But they, may not be as effective as a non-compete. And, it wasn't really part of the question, but the, like, where do I see, things going here from a litigation perspective? I think it will actually increase litigation between companies when you have employees moving within your industry. I think the non-compete obligations, generally is what gets the controversy or conversation, depending on how you look at it, started between the companies. And a lot of it shakes out, as you're going through that kind of discussion with either your former employee or his or her prospective new employer. A lot of that can be shaken out, and many times you might reach a compromise and a viable solution. Now without that, you've got to rely on some of these other protections, and it takes a little bit longer for those to develop. That may be harder to detect. And of course, there's evidentiary concerns and issues, but I think you may see more litigation coming out of this as companies continue to try to protect their business interests.
Susan?
Thank you for having me. So Chimera is a chemical manufacturing company, and a lot of our trade secrets really are our compositions or formulations, and it's how we manufacture those chemicals. And it's a lot on the application. So we already do a lot to protect our trade secrets and our confidential information. That could be by confidentiality agreements, our trade secret policies, access to information. But I think, as William said, the non-competes is a very powerful tool. It does prevent your competition getting access to some of your most critical information and getting that competitive edge. So it is one of the tools in the toolbox that if there is ban and if it is not enjoined, will be somewhat problematic. We are looking and will continue to look at what we do to enhance the protection of our trade secrets and confidential information. Do you envision, if the rule is not enjoined and it does proceed, there is likely to be a shift in that litigation. It will be going from whether or not your non-compete is enforceable under state law versus, do you have violation of trade secrets and confidentiality? And so I think there is a lot to be done in the organization and a lot of coordination with various different teams, be it the legal teams and R&D, and really monitoring this closely.
Thanks, Susan. Ben, do you want to turn back to talking about what the FCC has been doing in the way of enforcement action, sort of above and beyond the promulgation of the rule?
Yeah, and let me just comment on what William and Susan talked about. If you look at the comments from the FTC and a lot of the comments, there were more than 20,000 comments that were provided by the public and by companies and by business organizations, academics, et cetera, that there's this sort of tension where you have, on the one hand, the folks that say that you need non-competes in order to adequately protect your trade secrets and confidential information, and that barring someone or prohibiting someone from going to a competitor in the first instance doesn't even put your trade secrets at risk, and that's why they are a valid tool to use to protect trade secrets. And from a policy perspective, we had the DTSA, the Defend Trade Secrets Act, at the federal level in 2015. There's been follow-on legislation, more and more federal legislation trying to protect trade secrets, and there's certainly an argument to be made that this is inconsistent with that. Now, on the other hand, what the FTC says is that you have the trade secret statutes and you have all of these other restrictive covenants you can use, and that a non-compete overprotects your interest in your trade secrets. And that it's, I think there's some literature that calls it a blunt instrument that is used to protect trade secrets. So that's where the tension is on this issue. And, as William and Susan indicate, certainly in their companies, the use of non-competes is an important tool to protect trade secrets. But, I think the thing that I alluded to earlier is that at the time the FTC announced the proposed rule in January of last year, They also announced 2 enforcement actions, and there have been several since, that companies need to be aware of, because this is as important, as I said, as understanding the rule and what's going on with the rule. And so those enforcement actions, a couple of them that we've listed here, the Prudential Security, for example, was a national security company that was having its hourly, lower wage, minimum wage security guards sign non-competes that prohibited them from working within a 100-mile radius of any location they worked at for Prudential for 2 years. And they had a liquidated damages clause, or a penalty clause, if you want to call it that, of $100,000 for any violation. And they were suing their former employees who were violating them. And in some instances, the courts were finding their non-competes unenforceable, but they kept suing. And then OI Glass is a glass food and beverage container manufacturer. They had 1-year non-competes, also with hourly workers, and there were, thousands of them that they had signed them. And I think it's important to look at, the relief that the FTC obtained in those enforcement actions. They ordered the companies to cease enforcing or threatening to enforce the non-competes on the relevant workers, that they had to notify all affected employees that they're no longer bound by the non-competes, that they're banned from communicating to any relevant employee or other employer that the employee is subject to a non-compete. They're required to nullify the non-competes without penalizing the employees. They were required to provide a copy of the FTC's complaint and the order to all current and future directors, officers, and employees of the company who have responsibility for hiring and recruiting. And for 10 years, they were to provide clear and conspicuous notice to any relevant employees that they may freely seek or accept the job in competition with the companies. And so, the FTC's position is, regardless of the validity of the rule, that under the FTC Act, Sections 5 and 6 of the FTC Act, that the FTC has the authority to engage in these enforcement actions. And so I think that's something that we're going to continue to see regardless of what happens in the next week or so with the litigation involving the rule. And so I think where companies really need to be aware of this, these developments really involves lower wage workers and the, sort of the overuse or mass use of non-competes for folks who don't have access to trade secrets or don't have other, where the company can't really articulate other legitimate business interests that they're trying to protect through the use of the non-competes.
I have a question for Susan and William, and it's a bit more of a practical one. Obviously, all the outside counsel in the audience, in the room, and online, and Ben and I were fielding questions from clients about this rule. What has it been like within your organizations where, several months ago, employees, whether it's management or below management, are reading New York Times articles and Wall Street Journal articles about the FTC's ban? It's here, and there's probably chatter about what it means and what it means for non-competes, and particularly within companies. I'm curious if you could speak to what that's been like in navigating that in your experience.
Sure. Great question, and I've had a lot of inquiries, in part because we got ahead of this in the organization. So when the rule came out in 2023, we provided presentations to the senior management so that they would be well aware and know what to anticipate. And so this is something we've given periodic updates and continue to do so. Nonetheless, there has been a number of inquiries since this rule has gone into effect, and we've gone through the history with them. There's a number of people that will come to you always with some misunderstandings or a different spin on it, but always understanding, are they asking for them individually or for their team for whom they're managing? And so understanding the context of the inquiries, I think, is a very important thing to do. We like to educate people, and I think they are out there. There's so many tools that they have that they could educate themselves, but we are basically unequivocally stating that there is non-competes are valid and enforceable pursuant to state law until at least September 4th or sooner if this rule is enjoined. So that is our starting point, but letting them know that what is the current litigation that is ensuing, what to expect. We are just trying to just keep everyone well informed, but there continues to be and will be many more inquiries as we proceed. And We also talk about what that means educating on the current state of play, which is when you're dealing with a multinational and also when you're in multiple states, it's a patchwork quilt of laws. And so having them understand about the issues with enforceability, particularly you've had litigation on non-competes, and some of your management may get involved in those matters as well. Whether you're pursuing someone and trying to enforce your own non-compete or someone's trying to enforce theirs. So we have a really well-educated team, and we continue to have a really robust dialogue with them on this.
Our experience has been quite different, actually. We've heard very little from our employees and from our other management staff. Of course, we've just communicated the developments in the law so that our management teams are aware of it. And I was anticipating receiving questions both internally and with respect to hires that we're making, new hires. But it's been relatively quiet. I think our message has been, until the law goes into effect, or if the law goes into effect as scheduled, until then it's business as normal. And so we do treat our non-compete obligations as being enforceable as written, and we continue to do business as normal. Meanwhile, we do prepare for the rule to come into effect, and that's driven a lot of activity. And I think we may address that a little bit later in the program.
Ben, do you want to jump in now and tell us more specifics on what exactly the FTC's rule is and what it does?
Yeah, so let's talk about the rule. The rule provides that non-competes are an unfair method of competition. That's the basic premise, and that they're facially unfair because they're restrictive and exclusionary, and because they're exploitive and coercive. That's the FTC's position. And so there's a ban on non-competes, and the rule requires that companies give notice to all employees with existing non-competes, and that's current employees and former employees, that they will not be enforceable starting on September 4th, 2024. And importantly, and this goes back to what I said earlier about, as we all know, there's a wide variation among the states in state law with respect to non-competes, and this rule supersedes any state law that would allow a non-compete to be enforced that is in violation of the rule. So, the rule itself says it's an unfair method of competition for an employer to enter into or attempt to enter into. So you can't even ask an employee to sign. That would be an unfair method of competition. A non-complete clause with a worker, maintain with a worker a non-complete clause. So if you already have it in effect, and we'll talk about the exception for senior management that did get built into the rule, or represent to a worker that the worker is subject to a non-complete, where the employer does not have a good faith basis to believe that the worker is subject to an enforceable non-compete. And so how do they define a non-compete? And the definition is that it includes a term or condition that prohibits, penalizes, or functions to prevent a worker from basically competing. And so I think it's important to look at the language there. The prohibits part is easy. That's a non-compete that prohibits someone from going to work for a competitor. Penalizes, though, is one that's real important, right? We have lots of situations where companies have deferred compensation plans or stock option plans or other financial incentives to not go join a competitor. And so the rule says that if you lose that deferred comp, or you're forfeiting those stock options, or you're penalized in some financial manner if you go to compete, that is also a non-compete that is barred by the rule. And then that last phrase, functions to prevent, the original proposed rule had a reference to de facto non-competes. And there was a lot of hand-wringing and consternation around that, because there was some suggestion that even an overbroad confidentiality agreement or an overbroad customer non-solicitation or no service agreement might be considered a de facto non-compete. And the FTC backed off on that language in the final rule, but included this functions to prevent language. So for example, if you do have a confidentiality agreement that says something like, you can't go work for a company that would likely result in or have the risk of disclosing our confidential information or trade secrets, arguably that is a provision that might function to prevent somebody from working for a competitor, and at least in the FTC's view, might be considered a non-compete that's banned by the rule. And to William's point, I think that's where a lot of the litigation is going to be if the rule stands, is over what are the types of covenants beyond a true non-compete that might be deemed to function to prevent a worker from working for a competitor. There we go. So then let's talk about how is a worker defined. And a worker is defined extremely broadly under the rule, as you would expect. The FTC's view is that it's not just employees, it's independent contractors, it's externs or interns, volunteers, apprentices, sole proprietors, pretty much anybody that is working for a company in some fashion. Now, the term worker does not include a franchisee in the context of a franchisee-franchisor relationship, so they do exclude franchisees, but it does include natural persons or people who work for the franchisee or the franchisor. So as I just mentioned, the forfeiture for competition clauses, and basically the rule says that a provision is unenforceable if it penalizes an employee by forfeiting compensation if they work for a competitor. And that would apply, for example, with a severance arrangement where an employee is only paid if they refrain from competing, or if there's liquidated damages if someone were to join a competitor post-employment. I think one of the things to think about, for example, is with a severance agreement, sometimes severance agreements say, well, if you get another job, then you forfeit the severance, right? I think that's an open question as to whether the FTC would consider that to be essentially a non-compete, or whether that's a valid forfeiture provision that has existed in severance agreements for as long as I can remember, and probably for as long as there have been severance agreements. How do you protect, or how do you go about protecting trade secrets? What are the alternatives if the rule stands? Obviously, there's trade secret law. We've talked some about that. There's NDAs that we've talked about. Fixed duration provisions, as most people probably know, in the entertainment industry and the sports industry, fixed term employment contracts are very common. And so that might be a way in which employees can be at least restricted in some fashion, as if they're subject to an agreement for a fixed term. Even in California, I believe, where non-competes have been illegal for over 100 years, that type of agreement can be enforced. And so I think that, what we as lawyers are going to need to do, and clients are going to need to do, is sort of think outside the box about ways in which people can be restricted from working for competitors without running afoul of the rule.
Before I jump in and talk about the senior executive exception, Susan and William, I'm curious if your organizations, if you have thoughts on these alternatives to non-competes that Ben was talking about. How do you see those serving the role that non-competes in some ways do, which is being used as a prophylactic tool to protect against the theft of trade secrets?
Yeah, certainly these are valuable tools as well, right? And we've touched on it a little bit already. But I think you'll see companies looking to these provisions much more carefully, and we'll make sure if they're revisiting employment agreement restrictive covenants before the rule goes into effect, companies will be taking a very close look at these to ensuring that they can maximize their protections while also remaining compliant with the rule. California has been, I guess, a decent precursor on this, right? It's prepared most companies to do business in that state without having a non-compete. So you look at these other provisions. So as we look at our employment agreements going forward, and and how we'll structure them. I'm sure we'll look to our California provisions and see where we can replicate those on a broader scale that still complies with it. With the new rule, and obviously non-solicitation agreements are important, both customer facing and supplier facing. I do have a question about the fixed duration provisions, and how does that align with the provision in the rule about the forfeiture provision, right? So if you have a fixed contract term, like typically in the athletics arena for the college level, you see some sort of buyout provision, and that would seem to operate as a penalty. So are those, can they coexist?
Yeah, I'm not sure that a contract for a specific term is going to be a panacea that automatically gets you out of the rule, because you're right. If someone has a contract for a fixed term and they breach it by leaving and going to a competitor, would you be able to contend that a remedy you're entitled to is an injunction prohibiting them from working for that competitor because they're under contract with you for a period of time? And I think that's an area that's untested, at least, again, I've seen in California where the courts have enjoined people from working for a competitor if they're still under the term of their contract. But I don't know whether the FTC would view it the same way.
Interesting.
A related provision is notice provisions, right? Notice provisions are, a tool that companies use to not necessarily prohibit competition, but to, give a runway for the orderly transition and protection of customer relationships and ensuring that confidential information doesn't leave the organization. I think in Georgia and in many jurisdictions, notice provisions are considered reasonable and enforceable, aren't considered a restrictive covenant, aren't considered a non-compete. But if there was a 180-day notice provision, would the FTC look at that as, that has the functions to prevent someone from choosing alternative employment with a competitor? The FTC might take the view that that comes within the definition of a non-compete.
That's a really interesting thing to think about as well too, right? The notice provision. Our experience is that the prior employee and his or her prospective employer don't necessarily abide by the notice provision and fail to provide it, and so there's been a breach of that covenant against the company. But what's the company's recourse?
Right, and I think that's the challenge, right, is that with a notice provision, even if it's only 30 days, to get an injunction saying that someone can't start working for the competitor, I think will still be a challenge. It will be a challenge if the rule stands, because even I've litigated this issue a number of times where we were defending somebody that breached a notice provision, and our argument is, look, you can sue them for damages for breaching the provision, but you can't get an injunction requiring them, involuntary servitude went out with the 13th Amendment. You can't require them to continue to work for the former employer. And so I think you have a similar issue here where it may be that you could sue for damages for breach, but you're probably not going to be able to get an injunction that prohibits someone from working for the competitor, even if they violated the notice provision.
I agree, all those tools are things we're going to need to really look at. I think we're going to continue to look at the non-solicitation in particular to make sure they're not overly broad, but provide a good bit of protection. I think, however, the non-solicitation only gives you limited protections in non-compete, such a broader tool with greater protection. So it won't quite get us there. I am curious about whether our organization will continue to look at perhaps being more restrictive on limiting the access to trade secrets, to doing more on the exits when employees are leaving, and securing those laptops immediately, maybe doing some more forensics. So there's different things. I think we're going to need to partner with different groups within the organization, whether IT team, maybe externals, just to make sure things are not leaving the company when the individuals leave. So I think perhaps making those systems a little bit more robust and some additional procedures are things we're going to look into. So we're just starting to embark on those conversations now.
Ben alluded to the exception for senior executives that's in the revised final rule, and this was a response to comments that were submitted that you took the position that the a ban on non-compete shouldn't apply to senior executives that are in had the ability to bargain for and reasonably negotiate contracts that included non-competes. So the FTC's final rule includes this exception, but it is only an exception for existing non-competes. So what that means is if a company has a non-compete with someone who qualifies as a senior executive under the rule, which I'll talk about, that non-compete is not necessarily deemed invalid by the rule if the rule ends up taking effect. But the rule on a go-forward basis, the rule does not allow for new non-competes with senior executives. So really the question is of the existing non-competes with senior executives, who are senior executives who have non-competes, and an evaluation of do those non-competes continue to remain in effect. So now let's kind of talk about what is a senior executive under the rule, because it's a little complicated, a little muddy, like much of the rule is. So a senior executive is a worker in a policy-making position who received from their employment at least $151,000 and $151,164 in total compensation annually. So it is a combination of both a jobs duties test and an earnings test. There is more detail within the FTC's commentary and within the definitions of the rule as to what exactly is a policymaking position. And the definition of a policymaking position, it's a business entity's president, CEO, or the equivalent, or any other officer of a business entity who has policymaking authority for the business entity, similar to an officer with policymaking authority. So that includes an officer of a subsidiary if they have policymaking authority for the common enterprise, but it might not include that same person if they just have policymaking authority of a subsidiary or an affiliate. And that's actually taken from the language of the rule itself. But if you look behind in the 600 pages of commentary that kind of spells out what does the FTC mean and what's it really thinking behind these definitions, what the FTC is really getting at is, they're looking for the senior decision makers in the entire organization. So if an organization has 8 affiliates and there is what's called 8 subsidiaries, and there's a subsidiary and it has its own president, but that president is just the decision maker for that particular division or subsidiary, but doesn't have influence and doesn't have decision making for the entire organization. Under the FTC's view, based on their commentary, it appears that the FTC is going to think that while the president and the senior leaders of the entire organization are senior executives, that president of a subsidiary may not be considered to have, quote, policymaking authority and may not be considered a senior executive. The other components of this to think about is within a really large organization, suppose there is a chief marketing officer that is making a 7-figure compensation package. If that chief marketing officer, if their decision making and their influence is confined to the marketing division and that area, they may not have policymaking authority for the entire organization. They just kind of have that piece, even if they have some influence over other aspects of the organization. The FTC would probably take the position that they are not a senior executive within the meaning of the rule. So what does all this mean is that, organizations, particularly large organizations that have significant numbers of senior leaders and potentially have divisions and subsidiaries and affiliates, you're having to do the analysis of, is this person a senior executive within the meaning of the FTC's rule? And, with that, I'll actually ask Susan and William if y'all have taken the step of giving thought to who is or isn't a senior executive.
We have started this process, and I think it's going to be, the most important thing is to know your organization and know how you're organized. We have many divisions, we have subsidiaries and affiliates, and because we're a multinational, for the US-based subsidiaries, we're very unlikely, based on the final policy decision-making criteria here, to have senior executives. We are really looking at, for if this rule goes into effect, probably providing notice to, the white collar employees or the key employees. And we think that taking the broad, efficient approach there is probably the best way to proceed. But you really have to understand your organization and parse through all of this. But it is very narrow for senior executives.
Yeah, we agree. It's a very narrow exception here, and really viewed by us as being temporary, because it'll eventually cycle out on its own. But to the extent that the exception exists, we'll try to maximize its use and get the full benefit of the protection that we can. And I appreciate the attempt here at having a bright line test. But it's I don't know. I think it's reflective of not truly understanding businesses and industry and how it works, right? Because while there's some level of protection that's provided by this, it seems like they just missed the mark, right? The threshold should have been something different, and it's extremely difficult. And I understand that there are two prongs to this, right? It's not just a compensation analysis, because it's also a role and duty analysis, but the compensation role, I don't think is very meaningful. It sounds like a nice salary, but depending on where you work and your geographic location, that can vary greatly. And you can have employees in other roles too that still work with very, very valuable information that could be misused outside of the company that are below this threshold for the exception.
Yeah, I think this is an area, I mean, as William pointed out, it's temporary, so I don't think it's going to last long, but I think there's going to be a lot of litigation over this issue. Lena Khan, who's the chair of the FTC, she was on Squawk Box, and I forget who the host is of that program, but, the host said, well, does that mean I can just walk across the street and go to, I think Squawk Box is NBC maybe, and can I go to ABC? And she said, well, of course, you qualify under the senior executive exemption. And, that makes no sense based on this definition, but she's on record as having said that on a national TV program. So I do think there's going to be a lot of disagreement about who qualifies as a senior executive. The language is narrow, and the commentary suggests it's even narrower, but then comments that are being made by folks at the FTC suggest that maybe it wasn't intended to be quite that narrow. So we'll see.
Another exception to the rule is for covenants entered into in connection with the sale of a business. The original rule that was proposed in January 2023, it had it cast a broader net for covenants, sale of business covenants, and the only sellers who could be subject to non-competes under that original proposed rule were sellers who sold 25% or more of their business. And there were a lot of comments submitted that pointed out the sort of illogic in that if, five friends from college start a tech company and that company becomes a $500 million company and they each own 20% of it and get $100 million in a sale, then they couldn't be subject to non-competes under the the FTC's proposed rule. So the FTC did actually revise the exception to make the exception a little bit broader. It does not, so the requirements of the rule do not apply to a non-compete entered into pursuant to a bona fide sale of a business entity or of a person's ownership interest in a business entity or of all or substantially all of a business entity's operating assets. There's some commentary on, what is a bona fide sale. It's a sale between two independent parties made in good faith where there is a reasonable opportunity to negotiate the terms of a sale. Ben and I were talking about this morning that sort of begs questions of, well, if there are minority owners in a business that get pulled along and are, forced to participate in a sale and have to sign non-competes in the stock purchase agreement as part of that sale, if those particular sellers didn't have a reasonable opportunity to negotiate the non-competes, is the FTC going to consider them subject to the rule or part of the sale of business exception? That's another issue that could potentially be litigated as this rule plays out. But it's definitely, I think most would say, a step in the right direction. There was significant concern that the breadth of the FTC's proposed rule could have a negative impact on the M&A markets. And this rule, the changes that they made certainly seem to address that concern pretty significantly. William and Susan, I'm curious, as companies that are in the business of occasionally acquiring other companies, what's your reaction to what the FTC did here when it made the sale of business exception narrower in this final rule?
I still think there's a tremendous amount of uncertainty here, so I am concerned. I think the due diligence, what we're going to be doing when we're acquiring a company, is going to be more than in the past. I think in the past, you were able to look at what they had for non-competes, not only for their employees, but in the sale of the business. And here, I think we're going to have more due diligence in looking at policies and what they're doing.
Yeah, I guess I'm grateful for the fact that this exception is there, right? Because the proposed rule exception, while it was there, was quite scary. 25%, I think, was the threshold, and so I think that's another reflection of just being a little out of touch, because that your percentage greatly misses the mark in the modern M&A environment. But there's a lot of questions that are still left, right? Exactly, what's an owner of a business, right? You see a lot of instances where there may be incentive equity that's been in place with management team or key personnel at the target company, and if you have incentive equity that maybe some of it's vested, maybe it vests at the time of a sale is triggered, or are you an owner of a business? So does it apply then? Even worse than that, sometimes you see target companies that have some form of ghost equity or transactional based bonus. So I think those are open questions. I imagine there'll be a lot of litigation around that, because I think the acquiring companies are really going to continue to try to protect their interests there. Those are some of our concerns in that area.
William, have you gotten any sense for, what this might do to the M&A market? Because it certainly, the original rules suggested to me that you could decimate the M&A market with this. I don't know if because I know you all are pretty active in that area.
Oh, yeah, I think if it was a 25% threshold, that would have had a very negative impact on the M&A market. This exception is better. And as I said before, with the senior executive exception, I appreciate the attempt at having a bright line rule, but this is better than having a bright line rule that the threshold is going to be 25%, unquestionably. And also, I believe it's a good point too about Looking very carefully at what the target company has done, pre-merger or being acquired, to protect their intellectual property, and what mechanisms are in place there, as you go through the due diligence process. Susan's point there, I think is right on.
Ben, I'll turn it back to you to talk about the other exception under the rule.
Yeah, so there is another exception exists as to existing causes of action. And so the rule provides that if a cause of action related to a non-compete accrued prior to the effective date, then it is not covered by the rule. So I do think this is significant because it doesn't say that there has to be litigation that's already been filed. So if someone violates a non-compete today, under Georgia law, you got 6 years to sue them. And under this exception, I think you'd be permitted to do so. Now, I do think that judge is going to be looking at this and whether you can sue for and get an injunction or whether you'd be limited to seeking damages is an open question. But the rule does provide the opportunity to pursue existing breaches. There's also a good faith exception. And I think really some of the things we've been talking about here with the senior executive exemption, with the sale of business exception, that to the extent that you're operating in good faith and a good faith interpretation of the rule, if you turns out that the FTC disagrees or ultimately a court disagrees, you do have this sort of safe harbor that it's not necessarily a violation of the rule to have pursued somebody that you believed in good faith was not subject to the ban.
One thing we want to briefly mention is that there are some industries that do not come within the FTC's jurisdiction by statute. They're up on the slide. One particular area I want to mention is nonprofits, and the area where there's a significant amount of talk is nonprofit healthcare systems, where you do see a lot of non-compete activity. One consideration is the FTC's commentary. They suggest that there could be greater scrutiny of are nonprofits kind of truly nonprofits. There's some data cited in the FTC's commentary behind the rule that I think they say some significant portion of the 58% of hospitals out there that claim tax-exempt status as a nonprofit organization likely actually fall under the FTC's jurisdiction. The other thing to be thinking about as you're looking at particular situations is, well, what happens in situations where a nonprofit is contracting with a for-profit business or is partnering or in a joint venture with a for-profit business, or employees that are involved in whatever services that are being provided. Are they or are they not covered by the ban? That sort of the classic example is the nonprofit hospital system that contracts with a for-profit physician practice group. The physicians that are working for the hospital through the for-profit physician group are likely going to be covered by the ban, at least in the eyes of the FTC.
So the rule also provides this rescission requirement, and it provides that companies or employers have to rescind any non-competes by the compliance date. This requires actual notice to the employees. And the rule provides it can't just be a mass communication, but it has to be on paper or digital format. So email or text messages are sufficient. Helpfully, the FTC has provided a sample notice, so we don't have to, you all don't have to pay a bunch of lawyers to draft the notice for you, but
What if we don't like the notice?
I did another seminar.
Qualify that notice.
I did another webinar where someone put in the chat a question about why did they require a notice if this is all over the news, everybody knows about it, and my answer was they required the notice. It doesn't really matter why. But Susan, to your point, there's certainly something to be said, particularly with the litigation that's going on, about whether the notice can be qualified in some manner. That if this rule is ultimately found to be valid, then this notice is, we're providing you with this notice or something to that effect, because obviously the rulings we're going to get in the cases Neil's going to talk about in a minute are going to be trial court rulings, and we may not get rulings from the federal courts of appeal or the U.S. Supreme Court until after the effective date. And so companies are going to have to make a decision about what to do in the meantime.
William and Susan, what's been your perspective, and what steps are you taking, or you may be taking a wait and see as far as tackling the notice requirement and who to send to and how to send it?
I'm having meetings already with our HR colleagues, and we are planning on providing the notice. Again, I would love to qualify it. So if it is not enjoined before September 4th, we already have a date in advance of that where we will be sending it out. But again, we're not going to go through every severance agreement and every business protection agreement. We're going to take a broader view on that for efficiencies, and just take a period, the longest, non-compete we may have, and do the look back of those employees and send it to, probably by email, to the last email on file or their address. So we're working through those issues now.
Yeah, we're doing the same. We're working through the issues and haven't made final determinations, but looking at who we think may fall within the senior executive exemption or business sale exemption. And when it comes to notice, we are preparing to send the notice, and we'll be prepared to send the notice. But until September 4th, otherwise it's business as usual, and so we continue to use non-competes in our employment agreements where appropriate.
So turning to the lawsuits that are out there challenging the rule, where they stand, we're all kind of on the tips of our toes, kind of waiting to get a ruling. But just to kind of talk about what the cases are and how they got to their current status, there's really three lawsuits. One is the case filed by Ryan LLC in federal court in Texas. Ryan's a fairly large, about 4,000 employee global tax services firm. They were the first to file. They filed litigation challenging the rule, I believe, the afternoon that the FTC promulgated the rule. The U.S. Chamber of Commerce, they also filed a case in federal court in Texas the following morning. They're a plaintiff in the case, and there's also a local business roundtable, a local chamber of commerce, and a local business association that all filed a case. So those are the two cases that were filed in Texas. Separately, there's this ATS Tree Services case that was filed in federal court in Pennsylvania. This is a small tree cutting company. I think it's probably under 20 employees. And according to the complaint, they have figured out the secret sauce on how to trim and cut trees. They use non-competes with their employees to protect this specialized training, and they filed litigation challenging the rule. There appears to be a kind of a conservative think tank that is periodically challenging what they view as government overreach, and it looks to us like they sort of hand selected the type of plaintiff that they were looking for, as opposed to sort of the, an organization like the Chamber or a large company like Ryan. They picked out this mom and pop tree cutting company to pursue a challenge. So what are the arguments that are being made in these cases? And they're by and large pretty similar. And there's also been a large number of amicus briefs filed in each of the cases. The starting point, the primary argument, is that the Federal Trade Commission does not have statutory rulemaking to regulate in this area, that the rulemaking that Congress did give, which is in Section 6G of the FTC Act, does not reach regulating. A lot of us think that the FTC is legislating, but well, the argument is that they are not permitted statutorily to issue regulations regarding non-competes. Sort of the secondary argument is if the FTC does have rule-making authority, then that grant was a unconstitutional delegation of legislative power by Congress. Another argument is sort of similar, that there's not been an explicit delegation from Congress for the FTC to regulate non-competes. Another significant argument is based on the major questions doctrine that came out of the West Virginia versus EPA decision from the Supreme Court from several years ago. And what essentially came out of that case is that when you have questions of significant economic impact, which if you look at the FTC's commentary, the discussion of the economic impact that the FTC has on worker wages, and that's in the billions of dollars. There's really no dispute, I would imagine, even from the FTC, that this rule does have economic significance. Sort of the second part of the major questions doctrine is, is this an issue that's typically reserved for the domain of state law? That's something that clearly non-competes have historically always been an area of state law. We're going to talk about how that's resulted in significant divergence from state to state. And then the other thing that the West Virginia versus EPA case looked at is, has Congress either acted or declined to act? And in the case of non-competes, there's been significant proposed legislation, we're going to talk briefly about that as well, that Congress has chosen not to act on. So the major questions doctrine, it's a significant constitutional development where the Supreme Court is reining in what agencies can't do, and when you've got matters that check these boxes and involve a major question, that is something that should be handled by Congress in the Supreme Court's view and not delegated to a federal agency. Another argument that's being made in these cases is that the rule itself is arbitrary and capricious. That's something that some of the amicus briefs that have been filed in opposition to the rule, there's also been amicus briefs filed in support of the rule, but the arbitrary and capriciousness of the rule is something that's another argument that's been raised. So what's the status of these cases? So the Chambers case, kind of cutting to the chase on where the cases stand. The Ryan LLC, they were the first to file a case, and it turns out that Ryan is a member of one of the business organizations that's a plaintiff in the Chambers case. The FTC filed a motion essentially arguing that because of that, Ryan was almost going to get two bites at the apple through the representative organization and through Ryan itself. And the judge essentially accepted that argument and didn't transfer the case, but essentially stayed the case and allowed the chamber and the other plaintiffs in that case to move to intervene in the Ryan case. They moved to intervene. That was granted, and now the two Texas cases have essentially been folded into one. In both that Ryan Texas case and in the ATS case, both the plaintiffs in those cases have filed motions to stay the rule, stay the effective date of the rule, which I don't think we've actually mentioned it today. The effective date of the rule was 120 days from when the rule was promulgated. I don't remember the exact date it was promulgated, but the effective date that we're talking about is September 4th, which is coming up. So the motions are seeking to delay that effective date or to enjoin enforcement of the rule entirely. Those, at least in the Ryan case, those motions are now fully briefed. I think in the ATS case, they're either fully briefed or there's one reply brief coming. The judge in the Ryan case, she recently issued a notice saying she's not going to hold a hearing, she's not going to have oral argument. She's just going to rule on the papers. And the judges in both these cases have, based on the scheduling orders, the briefing schedules that they've issued, they're very mindful of the upcoming effective date of the rule. So the judge in the Texas case, which we have three Emory grads on the panel, many in the audience, many in the online audience perhaps, She's an Emory Law grad. She said she's going to rule by July 3rd. The judge in the ATS case, she's going to rule by July 23rd. I think the other judge is he's going to rule by July 23rd. So we should be getting a ruling almost any minute now, any day now. If it comes out on July 3rd, we'll all have, those of us who are following this closely, will have something to sit by the pool and read on the July 4th holiday. But the rulings are coming. Obviously, from there will be there'll be appeals to circuit courts and possibly to the Supreme Court. With that, I'm going to turn it back to Ben to kind of take it from there and talk about what's going on in the state law world.
Yeah, just real quick I think I mentioned earlier this issue where this is potentially a bipartisan issue. There have been a slew of amicus briefs filed in both cases. But one that was interesting to me was Representative Matt Gaetz filed an amicus brief in the Texas case in support of the FTC and in support of the rule. So even though, the commissioners voted along party lines, again, you sort of have this other element in the Republican Party that perhaps is supportive of the rule or of regulation of non-competes. But I do think it's important to talk about what's going on at the state level, because regardless of what happens with the litigation and the ultimate validity of this rule, there have been significant developments in various states that have a real impact on how companies can use non-competes. The biggest one is wage thresholds. There's at least 10 states now that have wage thresholds. They're all over the board. In my view, wage thresholds are a little bit arbitrary, right? Someone could be making a relatively low amount of money, but have access to trade secrets or other protectable interests of the employer. But there seems to be this trend that lower wage workers should not be subject to non-competes under any circumstances, and that's really what we're seeing play out. I think those of us who were following the FTC's actions and rules were perhaps hoping that they would take a similar approach and not have a complete ban, particularly as we were talking about with high-level executives. It's much harder to make the argument in favor of the ban, but they didn't, and they went for the full ban. But at least at the state level, the wage thresholds have been a big one. The other elements in some of the state legislation, first of all, if someone is terminated without cause, there are some states that have said that non-competes cannot be enforced in that context. Notice requirements are becoming a big one. Massachusetts, Illinois, and others are enacting notice requirements. I can't tell you how many times, especially earlier in my career, I would get a call from an individual who had just moved to Atlanta, sold their house in New York or New Jersey, wherever they were from, moved their family here because they had a great job with some tech company here, and they show up on the first day of work and they're asked to sign a non-compete that they had never seen before. And that is just not a good business practice generally, but it's something that happens all the time. And I think these notice requirements are trying to get companies to be upfront with people when you make an offer to someone for employment, that if they're going to be asked to sign a non-compete or some other restrictive covenant, that they're informed of that so they can make an informed decision about whether to accept the offer of employment. Others require counsel to be involved and have the opportunity for counsel to review the agreement. And then the other big one that we're seeing, California has gotten real aggressive with this, which is prohibiting choice of law or even forum selection clauses. So anybody that lives or works in California, if they work for Wencor or they work for Camara, but they live and work in California, they cannot be required to litigate in Georgia or litigate in any other state. California says that non-competes are illegal here, and you can't go in through the back door by enforcing them through litigation in some other state. And now we're seeing more and more of those. I think Minnesota, when they implemented their non-compete ban earlier this year or late last year, that also has a prohibition on those types of forum selection clauses. We're seeing a lot in the healthcare arena, states that are banning non-competes for physicians and other healthcare providers. I always think it's funny that, we as lawyers are not allowed to have non-competes, and that's not state law, it's our own ethics rules. But the rationale is that the public should have the absolute right to choose their lawyer. And, at least here in Georgia, we have the absolute right to choose our lawyer, but we don't have the absolute right to choose our doctor because, at least under Georgia law, non-competes are fully enforceable against physicians. But the other thing is that states are now broadening the definition of what constitutes a non-compete. If you have a covenant that prohibit the acceptance or not just the solicitation of business from a customer, but acceptance of business, at least in Washington, and I think there may be one or two other states, that is now defined as a non-compete. And then also no poach agreements or non-solicitation of employee provisions. So it is important if you have multi-state operations to be aware of what's going on. And as Susan, I think, mentioned in her opening remarks, it's become a real patchwork. It used to be you could have one agreement for pretty much everybody and have your exception for California. But now, I mean, we've been drafting multi-state agreements for employers the last year or so, and you've got, like this 3-page addendum to try to address all of the issues in the various states that have implemented some of these restrictions. And then just real quick at the federal level, beyond the FTC, as we've mentioned a few times, there has been legislation that's been introduced. Now, none of these have really gotten any traction, and I don't know if it's because Congress, the sort of paralysis in Congress, or if it's because there just isn't the political will right now to push this through. But these bills that we've got here on the slide have all been introduced on a bipartisan basis. And to me, the bigger concern for companies is the FTC rule. I think if we were betting, we're probably betting that it's going to be struck down at some point, whether by this Texas judge or ultimately by the Supreme Court. But if Congress acts, then that's going to be much more difficult to challenge in court. And whether it'll happen, I don't know. But if Congress does act and ultimately passes some kind of ban or restriction on non-competes, it's much more likely to stand.
Ben, we've talked about this a little bit along the way, but do you want to lead a discussion of what should companies and their counsel be thinking about now, be doing now in terms of protecting trade secrets, whether we have a ban that stays in effect or whether the ban gets enjoined?
Yeah, I think we've talked about a few of them. William and Susan talked about what they're doing in their companies. What we've been recommending to clients is that especially for larger organizations or for smaller organizations who don't have great record keeping, to at least be starting to pull together your lists of who do you need to provide this notice to, because we should find out next week if there's going to be an injunction. But like I said earlier, that doesn't necessarily mean that at the end of the day, you're not going to ultimately have to provide the notice. And so starting to put those lists together. But in the bigger picture, at the end of the day, we started with this discussion. I think it's where we can end, is that if your goal is to protect your trade secrets, your confidential information, the competitive edge your business gets from its information is looking at the things that Susan was talking about, looking at, going through an audit your business and figure out what is the secret sauce, what are the things that we really need to protect, who has access to them, what policies and procedures do we have in place to protect them, what agreements can we use to protect them. And, it makes it really hard when you go into court to tell a judge that something's a trade secret when the other side can say, well, Judge, they got 4,000 employees and every single employee has access to that information. Limiting who has access to the stuff that really is truly confidential. Just doing the basic things that you need to do in order to be able to establish that something constitutes a trade secret or at a minimum constitutes confidential information. So, those are the main things. There are other things that can be done in terms of compensation and other ways to incentivize employees to not leave and go to competitors. But I think that, especially for this group, the biggest one is on the trade secret side.
William and Susan, anything you'd like to add before we open it up for questions?
I think that's a really comprehensive list, and we certainly have some additional action items within my company and embarking on those. We'll be watching out for the July 3rd ruling, however, that we know will not be the end of it. So we're preparing.
Yeah, I agree, and Wincor is doing the same things, right? And it's a, you know, even if the rule is enjoined, it's been a wake up call, I think, for a lot of companies. You know, obviously these are important social and economic issues, you know, that are touched here, right? And, I think to Ben's point that even if the FTC's rule doesn't stand, there are other, you know, potential legislation that could come out, and certainly we've seen an increase, to Susan's point, about in various states, where you have you know, different rules, different levels of sophistication, right? So, yeah, I think as a company, you would be foolish not to be looking at other ways to enforce or to protect your trade secrets, confidential and proprietary information. Certainly.
Well, we have a few minutes left for questions. Are there questions from the audience, or we may have some questions from the online chat? Yuri?
Yeah, you can repeat it. We'll repeat it. No, right. Great question. I mean, I think in that context, they likely would not come within, there'd be an argument they don't come within the definition of worker. I guess they could try to argue that they're your independent contractors. So perhaps they would be covered. I hadn't really thought that through. If you all have any different view.
Do you need one? Why wouldn't you just have a confidentiality agreement limiting the purpose for which they could use your information? And then if they use it to compete with you, you would be able to pursue them. I mean, it doesn't get the toothpaste back into the tube, but I think you would have a very limited consultancy agreement with confidentiality and non-use. I feel ill-equipped, quite frankly, to answer that one. I am not patent counsel, but I don't believe it would. I think there's other protections you have by having your patent applications and assuming that with having your patents granted, rather. So I think you have to be really careful about what you do in practice prior to the patent being granted.
Yeah, I agree with Susan as well too. And I'm probably not qualified to answer it fully, but yeah, I'm not sure that it would drive us to do something different from a patent strategy.
Yuri's a patent lawyer. He's hoping that it's going to result in more patents. First of all, on the first question, the FTC didn't make that decision. Congress made that decision. The FTC just doesn't have jurisdiction over nonprofits. So that's why the rule can't apply to them. California, it's real interesting. Like when the Georgia statute was being debated here in the General Assembly, and the Georgia statute in 2011 was going to make and did make non-competes more enforceable, right? I had the opportunity to go down and testify at the General Assembly, and I had read some of these studies about the economic impact, and I sort of got the reputation as being opposed to the change in the law, which wasn't accurate. I was just down there like asking the question, has anybody thought about this? Are we looking at this from, is this good for economic development in Georgia? And no one had, they didn't care. But one of the studies that was done, and one of the studies that's cited, is there was a study that looked at, there's a corridor in Massachusetts where there were a lot of tech companies in the 70s, I forget, I-78 or 70 something. And then they looked at, why did Silicon Valley take off and become what it is? And why did that area stagnate? Now, Massachusetts today is a tech powerhouse, but for a long time in the 80s, 90s, they really weren't. And the conclusion was, well, because non-competes are illegal in California, it created this innovation environment, a free exchange of ideas, information flow, entrepreneurship, and that's why, and in Massachusetts, non-competes were vigorously enforced. Whether that's true or not, when I mentioned that to the folks at the General Assembly, Kevin Levitas, who's now a friend of mine, he said to me, well, where would you rather live, in the snow of Massachusetts or in the sun of Silicon Valley? And that was like sort of their reaction to that. I do think that one of the things that's real interesting to me is the business community generally in the United States has been opposed to this rule, except for the businesses in California. Because in California, they're looking at it saying, well, this is going to finally level the playing field for us, because lots of our competitors have non-competes, so we can't hire from them, but we can't have non-competes, so they can hire from us. So I think there's, the FTC's view, and I think there is some validity to the idea that California, I think, is the 6th largest economy in the world, standing alone. Like, so, is there something to be said for not allowing non-competes, and what is the ultimate impact on economic development?
There is far and away more trade secret litigation in California than anywhere else. So suggests that if the FTC ban isn't enjoined, it takes effect. Will you see that kind of trend in other jurisdictions, which would be good for trade secret lawyers like Ben and I. Right.
Yeah.
Right.
That's right.
There's an interesting thing to think about there too, right? Because even I would imagine in most jurisdictions in which you practice, you hardly ever see a lawsuit brought just on a breach of a non-compete.
Right.
Right. Surely there are other claims in there, whether it's breach of confidentiality, breach of fiduciary duty, trade secret misappropriation.
Yeah, absolutely. I mean, when the rule was first announced, I was joking in my office, I guess it's time for me to retire, given so much of my practice involves restricted covenants. But the reality is, of all the cases in our office, and there's a lot of them, very few involve, actually enforcing just a non-compete. Almost every single one involves other restricted covenants, involves confidential information and trade secrets and things of that nature. The only exception in California is sale of business, that you don't have the senior executive exception or anything like that.
And the California, the FTC's rule would allow for customer non-solicitation covenants. It would not ban non-solicits. California does not allow customer non-solicits, and the case law there has shifted to even ban employee non-solicits. Case law is not clear, but that's another thing. The FTC doesn't touch employee non-recruitment covenants either.
Yeah, it's a great question. I think that their view is even at the highest levels, it's anti-competitive, and therefore they should be banned. I think that, that the 600 pages of commentary sort of explain their rationale for that. But like I said, for every study that supports their argument, there's another study that that goes against it. So I don't have a great answer.
Yeah, and I don't think they liked the idea of drawing lines that were then likely to be circumvented by employers that wanted to continue using non-competes. I think they were of the view that this is something that needs to be extricated from our economy, other than covenants with these senior executives, and as opposed to sort of splicing and dicing and, leaving lots of room for argument and litigation over who's covered, who's not covered. I think they made just a sort of clear ban.
Yeah, I believe so. It's like garden leave provisions, right? I mean, I think that that gets to the forfeiture idea. That if you're forfeiting I realize it's sort of the opposite of that, but I think that's covered by the rule. Well, it depends, right? If the person accepts it, that's fine. But if the person decides, you know what, I want to go work for a competitor, I think that, if your agreement says that you're paying them so they can't do that, the FTC is going to say that's a non-compete. Dan's rolling his eyes. I'm not sure he agrees. No, right. I think that's right. If you're just going to sit on the beach, then perhaps the FTC would not say that is. But I think it's the person who decides, well, I can make more money by accepting this position with a competitor than you're paying me. So, thanks, but no thanks. And I'm going to go compete. I'm not sure you'll be able to stop them.
We are past our 1:30 time. We appreciate all the great questions. I want to thank Ben, William, and Susan for joining in this excellent presentation. We're happy to stick around for a few minutes if others have questions. Thanks everybody for coming. And one more pitch, like Mike said earlier, if you are interested in getting involved in our trade secret committee, please drop me or Mike a line. We'd love to have you, and love to have you at our next program. Thanks, everybody.
Thank you.